Hello everyone, in this video I'm going to talk about some articles in the Iraqi labor law number 71 of 1987, which are very important for you as HR practitioner, as employer, as employees to know about them, mainly related to the employee's contract. So one of the articles which is important for us to know is article number 10. It says that Arabic is the language to be used in all employment relationship. So whether involving contract, record, or any other document, that has to be in Arabic. So any documents, any records that we have with our employees within the company or the organization, it has to be written down in Arabic, except for the Kurdistan region, because the same article says or stated that the Kurdish language shall be used for the same purpose as Arabic in the autonomous region of Kurdistan region. So if your company is in Kurdistan, located in Kurdistan, if you're operating in Kurdistan, Kurdish could be used, Arabic could be used. So both language could be used, or you can use one of them. So it's totally fine if you are only using Kurdish or only using Arabic in Kurdistan region. So it's for Kurdistan region, but the rest of the Iraq, the rest of the country should be in Arabic. So that's what the article says. But we have one problem which is related to other languages. So according to the law, it says that no one relying upon the document drawn up in another language may prevail in a claim against a worker, even if the document bears the worker's signature. So even if I sign the contract in another language, I sign it as employee, then that may create a problem when my employer claim against me. So that's why you have to be careful to draw up all the documents, all the records, the contracts in Kurdish or Arabic. So since the article is applicable in Kurdistan, so it's better to write down your contract, prepare your contract, your documents in Kurdish or in Arabic. So now let's move to another article, which is Article 30. So according to this article, a contract of employment should be or must be in writing, and shall stipulate the type of work to be performed and the wages to be paid, the amount of wages to be paid. So we have three things here. The contract should be in writing. It has to be in writing. So I sign it, you sign it. It has to be on paper. We write it, we sign it. This is first. Secondly, the type of work that I'm going to perform or I'm responsible for, it has to be there. My job title should be there. And also the wages that I get, how much I get. So that my salary or the wages that I get, it has to be written in the contract. This is first. Secondly, what if I don't have a contract, a written contract? I have a contract, but I don't have a written contract. So when there is a problem, can I still claim against my employer when there's a problem? According to the Iraqi labor law, you can, but there is, there are some things that you have to provide. You should provide evidence in order to prove that the contract exists between you and the employer and there's a breach of the contract. So the proof and evidence should be there. It becomes a little bit complicated, but you can still claim against your employer, because according to this article, it says that if there is no contract, no written contract, so you as a worker shall bear the responsibility or bear the burden of proof to show that the contract exists and present evidence. So you have to provide evidence in support of any claim arising under the contract. So if there is any breach of the contract, and if you don't have any written contract, you have to provide evidence and you have to prove it. So another article which is about the probation period, because it's matter for many of us also. The probation period is 3 months according to the Iraqi labor law, or article number 31.